Even on the submission that my learned friend, Mr. Masharia, made before this court, that there was additional evidence that was entertained by the Speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission, my Lord. My Lord, that was a substantiation of a charge on economic crimes that failed. Only, my Lord, 5 out of the 11 charges proffered against the Deputy President petitioner hearing succeeded. Only 5 out of the 11 charges. How else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my Lord. That out of the 6 charges, my Lord, the Deputy President was convicted on the gross violation of Articles 10(2)(ab), 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national cohesion and on the question that is laid before this court, my Lord, that is on violating his code that requires him to undertake certain functions and undermining the function of the National Security Intelligence Service. Ms. Kimotho of Kimotho and Company Advocates would want the Deputy President to apologize on that count. That's a live matter. But my Lord, in the grant of conservatory orders, I submit, and this is because I argued Munya, I argued Wajir, I argued Munya, I argued Mate. So I'm an authority. Yes.
And I was with you, Professor. Professor, we have
the principles that the court considered, the Supreme Court considered in the Munya case. Public interest, I think, on the scales weighed highest. That this court must take into account the import of a conservatory order issued ex parte against public interest. My Lord, this is a country that is built on the Constitution of Kenya in 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 as a rider that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the Deputy President. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the Deputy President, my Lord and my lady, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a Deputy President sworn in because of the dictates of Article 131 of the Constitution. My lady and my lords, a conservatory order is therefore inconceivable in the terms defined in the Munya case. A conservatory order of the nature issued by Justice Mwongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect me. This court would only use that authority to support the appointment of His Excellency Honorable Professor Kindiki, so that this country moves to the second level. I would argue to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic. My lord, wherein would his remedies lie? But I'm friendly about him submit. If